Hi, and welcome to Evermore's monthly In the Know, where we get to meet with grief and bereavement experts or experts in bereavement and grief. And today I'm really excited to introduce to you Jeff Nowak. He is an FMLA expert, as well as an ADA, Americans with Disabilities Act expert, and in helping employers develop comprehensive strategies to achieve compliance with employee leave and accommodation concerns. Jeff is the author of a highly regarded FMLA Insights blog, which I highly suggest you check out. It's fabulously written and very entertaining, which has earned him entry into ADA's Journal's Blogger Hall of Fame, and that's awesome. We have a lot to learn from you, Jeff. He's a shareholder in Littler Mendelson P.C, which is the world's largest labor law practice representing management. He's a self-proclaimed baseball fanatic, an avid White Sox fan, and former high school semi-pro baseball umpire, which is really pretty impressive. He recently became president of Grange, Illinois Little League, fulfilling a dream that rivals his daytime job. Would love to actually hear more about that piece of your work at some point. I imagine that is just priceless, but welcome, Jeff, and thanks for being with us today.
Thanks, Joel. Nice to be with you as well.
So before we get started, I am just very curious, and we're curious, why law? Of all the things you can go into in life, why did law stand out for you?
I can go back to that umpire piece that you just read about. Coming out of college, I was frankly a hot mess. I wanted to follow several dreams, one of them being a Major League Baseball umpire. I also was considering entering the religious life, the Catholic religious life, and becoming a Catholic brother. I also had an opportunity to work for the Illinois governor coming out of college. So I was literally weighing those three options. I ultimately, because politics was my passion at the time, I wanted to be a politician. I wanted nothing to do with the law. And I was only interested in the law because all politicians are lawyers, right? At least that's what I thought at the time. It was actually a journey to becoming a politician. And then halfway through law school, I decided, wow, I don't really want to be a politician. I don't want that life. And I thought, oh my goodness, now I have to practice law. Here I am 25 years later practicing law. So it all worked out. But That's amazing. That's
quite
a journey.
Yeah, it sounds like it. So now you're in law, and how did you land on employment law?
Well, it deals with human beings. It is a very personal area of the law. I was not going to be an SEC attorney or a tax attorney. I was clearly going to do something that involved people. That was my natural inclination. And so thankfully, I don't know, it was something from above. During law school, I was actually taking a class. It was my legal writing class, and it dealt with harassment, sexual harassment in a school setting. It was peer-on-peer sexual harassment. And we spent our whole semester dealing with that scenario. And our legal writing class was based around that scenario. And I thought, wow, what a fascinating topic. Harassment, at least in that context, it was harassment in a school setting. And I carried that over in working with a federal court judge in between my first and second year of law school, where I spent a ton of my time dealing with employment law issues involving harassment in the workplace, discrimination in the workplace. And that's where I found my calling. Doing that kind of work for just several months coming out of law school after my first year, I thought, that's what I want to do. That's where I want to be. It deals with very real life issues.
I really just want to thank you for that, because in reading your blog, the human element actually really comes through, and sort of the sense of how can an employer or management system be sympathetic, but also appropriate around the law, and acknowledge people for sort of the human experiences that they experience. I think that just really comes through so well in your writing. Tell me, so now you're in employment law and you have sort of a plethora of opportunity there. How did you narrow in on FMLA, which is the Family Medical Leave Act, and ADA, Americans with Disabilities Act? How did you narrow down on sort of those two fields?
Yeah, as I grew in the practice of law, I've only represented employers my entire career. I've only represented the management side. And the further I got into my career, I certainly litigated my fair share of employment cases. And I naturally gravitated toward advice and counsel work. Where could I get into the trenches with my client, with employers, and help them make real-time decisions that are both fair to their employees and fair to their own operations and business goals? It was, again, that part of me that cared about the human element of things. And even drilling down further, what I found in my practice was the most difficult issues that HR folks grapple with, that business leaders grapple with as they're making employment decisions, are those that involve health, medical conditions, whether it's a leave of absence, someone who needs leave for mental health issues, physical issues, and also accommodations in the workplace, people who need help in the workplace to help them stay employed. And so I found that so rewarding that I could work with employers, people like you and me, people who generally care about others, to help them make decisions to help people keep their jobs. I couldn't do that on the employee side. I couldn't do that on the so-called plaintiff side, but I could do that on the defense side. I could work with day in and day out, as I do even today, help employers make good decisions that are fair, ultimately fair to the individual that's at issue, but also to their entire workforce. And plus, it's job security, right? I mean, there's always a medical issue going on in the workplace. Someone always needs leave. Someone always needs an accommodation. And so for me, it was a growing area of the law, and so that aspect of it was exciting to me.
Well, it just strikes me that this is such a wonderful blend of your interest in doing policy or potentially political work, but also really thinking about sort of that, Catholicism or, potentially pursuing that route. Like, you're really trying to preserve the human and the human experience and sort of have, employers and employers manage employees as well as they can, and to the extent of law. It seems to me like this is really sort of quite a logical blend, just given it doesn't include the baseball piece of it, but
yes, that's where Little League comes in, right?
I see.
That satisfies the baseball side.
So tell us what is FMLA? What is the Family Medical Leave Act?
Sure, and I assume that all of us on the call here today are generally familiar with the law. The FMLA stands for the Family and Medical Leave Act, and when we refer to the FMLA, we typically refer to the federal law. It's a federal law that provides up to 12 weeks of leave to an eligible employee. Not all employees are eligible, and we can certainly talk about that, but it provides 12 weeks of leave in a 12-month period of time for certain reasons. Because of the employee's own serious health condition, because the employee has to care for a family member with a serious health condition, or due to pregnancy, incapacity due to pregnancy, and also bonding time after the childbirth or adoption or placement into foster care. That's FMLA in a nutshell.
And who is covered by FMLA?
FMLA covers generally all public sector employers. It also covers employers that have private employers that have 50 or more employees. So that's the employer side. An eligible employee can only take FMLA leave after they've been employed by the covered employer for 12 months. So you have to have worked for 12 months for the employer. That need not be consecutive. So that's over a 7-year period of time. Have you worked 12 months for this employer? You also have to have worked 1,250 hours for that employer prior to leave beginning. So 12 months, 1,250 hours is really the key eligibility requirement for FMLA. At that point, then you're eligible to take those 12 weeks of leave in certain situations.
So is there any kind of sort of benchmark, hourly benchmark that an employee has to meet in order to qualify for FMLA? I mean, I know you said over the 7 year. What is the actual, is there qualifying criteria to be eligible?
Good question. 1,250 hours is going to be roughly 25 hours a week that you're working for the employer. It's a little bit more than half time. So it would cover most part-time employees.
Got it. Is there any exceptions?
Exceptions for FMLA? It really would only be.
Like who would not? Yeah.
What I find most in most situations, those who are not covered by FMLA are those who work for an employer with fewer than 50 employees. So that, so your smaller employers are not covered by FMLA. That pops up for the most part. Most of your situations where someone's not eligible, it means that the employer is not covered by the FMLA for your smaller employers, or you've simply have not worked enough hours. That's what I typically find is when someone's not eligible or they're in that first year of employment with the employer. Those are the most common situations.
So I'm thinking about, maybe there is a tragedy that's unfolding, for a family, and they don't know, is my employer, covered under FMLA in some way? Is there a way for families or for an employee to understand whether or not their employer has to follow the FMLA guidance?
Sure, a couple of ways. One is, does your family member have a handbook or personnel policies at home that you could review? Many companies have an intranet that can be accessed, that your family member who's employed by the company can access that intranet, even typically from home. If they log in, you can find policies there, or pick up the phone and call and contact the HR department at the company to determine coverage and the FMLA policy. It's really important for employees to know what that FMLA policy is. For many employers, it's a standard policy, but there are differences from employer to employer because the procedures can be driven largely by the procedures for requesting leave can be driven by the employer itself. So you have to be sure to follow those employer procedures for requesting a leave under FMLA.
Got it. And what about compensation? Is compensation part of FMLA, or is it not considered part of FMLA?
Well, we're in the middle of a bit of a changing landscape. By its very nature, federal FMLA is unpaid, and that remains today. And I would say for the foreseeable future, federal FMLA is going to be unpaid. But what we've seen as a result of Congress being unwilling to pass a paid leave law at the federal level, we've seen quite a bit of growth at the state and local level when it comes to paid FMLA leave. So again, federal level unpaid, state and local level, we're seeing every year, we're seeing several new laws come on the books, both at the state and local level, that provide either paid sick leave or paid family medical leave to employees.
So actually, that's a great segue into my next question around there've been some efforts on Capitol Hill to advance bereavement as a qualifying event for FMLA job protection. Barry Kluger, Kelly Farley are two fathers who've been working on that for a couple of years now. I think they've been tremendous champions for the issue. We certainly now have, I think because of their advocacy, they were able to advance childhood death or the death of a child as a qualifying event for federal employees under the National Defense Reauthorization Act. But we have continued to see the federal government be more limited in advancing bereavement leave protections, not even paid bereavement leave, just to sort of add that distinction there. Do you have any sort of thoughts generally or any observations that you might share with us on why maybe that's a sticking point?
Well, if I can pick on both our main political parties right now, on one hand, and again, I don't mean this answer in any kind of political way, but I think it's just the reality of the situation. Republicans on one hand have been reluctant by their very nature to require employers to provide paid leave as yet another entitlement in the workplace. They see it as an entitlement that they don't want to force upon American employers. That's the mantra, generally speaking, of the Republican Party. And I feel like I've characterized that fairly well. When one or both houses in Congress have been controlled by Republicans, this kind of law just doesn't see the light of day. On the other hand, for Democrats, there have been a select few that have championed the cause. But generally speaking, although you may see it in a party platform or you may see it as part of campaign materials, the reality is that the Democrats have not made this as big of an issue in among their priorities when we see the legislative agenda. It just simply hasn't been a priority for the other side. And it's for me, both personally and as a practitioner, it's frustrating. This is low-hanging fruit, right? There's some of us that have been lucky enough that have never had to deal with a medical issue that's affected them or a family member. But we've all lost someone in our family. We've all lost a friend, a family, or a family member or a friend. The loss of life has impacted all of us. So it's frankly shocking to me that this kind of legislation, bereavement leave, whether it's part of FMLA or it sits outside of FMLA, it's really shocking that Congress has not been able to rally around what I see as frankly low-hanging fruit. Generally speaking, employers see the need for bereavement leave of some kind. Why that hasn't happened at the federal level is really beyond me. And what we're starting to see, and we'll get to this a little bit later in our session, we're starting to see some of the states pick up where Congress has left off. Congress, it's very clear, cannot get their act together and pass, whether it's paid FMLA at the federal level, bereavement leave at the federal level. And so based on that inaction, we're seeing the states and localities pick up. So we're starting to see them actually enact legislation to provide bereavement leave at the state and local level.
Yeah, I would agree with that. And also, it was an interesting exercise that we led a coalition a couple of years ago and attached paid bereavement leave to President Biden's domestic policy agenda. It went to Congress, it went to the House, but frankly, as that Build Back Better began to sort of matriculate up, that was one of the first things to be stripped out. And the party in control there was also the Democrats. And so this is a long slog, I think. For us.
And for those of us on the employer side, I represent employers and I care deeply about them. I advocate for them, but this is good for employers too. And we're seeing this in the paid leave area as well. When Congress can't get its act together, we're seeing the states and cities enact all these different kinds of laws that make our head spin. We can't keep up with them. For those multi-employer companies, multi-jurisdiction companies, you're having to figure out the different law in every state. Well, if we had passed this at the federal level, it would have reduced the number of all these different state and local. It wouldn't have eliminated them, but it would have drastically reduced them. And ultimately, it would benefit employers. Same thing with bereavement leave. Not only is it from a policy standpoint a low-hanging fruit, like I've said, it avoids these states and cities from coming up with their own versions of bereavement laws that, again, will pull our hair out as to how do we handle our employee that sits in Illinois versus our employee that sits in Colorado and our other employee that sits in California. There's different bereavement laws in every one of these jurisdictions. It makes it tough for us to keep up.
Absolutely. And I think this is where the UK is really certainly in front of us on this. They have Jack's Law, which offers bereavement leave sort of universally across the country. I think, to your point, I think from an employment perspective, we'll probably get to a point where there is such a patchwork quilt, if you will, of different states and jurisdictions and localities with different laws that it will make more sense on a federal level, or we'll be able to garner more support for that.
Yes.
So one of the questions I have for you, so sometimes when I'm talking to individuals sort of outside the grief and bereavement field, they'll say to me, well, as long as someone has a serious medical condition or health condition, then they can just invoke FMLA. So just tell a grieving or bereaved individual that they have to report that they have depression or some other sort of clinical presentation, and they'll have access to leave. I have some other thoughts on this that I want to mention in just a minute, but I just want to sort of ask you sort of first, what is a serious health condition under the rubric of FMLA? We'll start there.
Sure. Well, under FMLA, serious health condition is defined as an impairment or a medical condition that either involves inpatient care, so you're at a hospital or a healthcare facility, typically for an overnight stay, or it involves continuing treatment, that you either have an extended illness that lasts for more than 3 consecutive days, and you have continuing treatment with a physician, or you have chronic or long-term medical conditions that require continued medical care. That's what's covered by FMLA, which of course doesn't neatly fit with our person who is grieving the loss of a family member or a friend, right?
Absolutely. Have you, in your experience, worked with an employer who maybe had employees who attempted to invoke FMLA for a bereavement-related event? And then I just sort of wonder, how did that go?
Sure. It's not uncommon when an employee loses a family member or someone close to them that they ask for time off. And oftentimes that can be time off above and beyond the bereavement leave policy that we might see the companies in the company's handbook. Oftentimes we see in these bereavement policies, it might cover 1, 2, 3 days of bereavement leave. That for so many people is not enough. The only way that today, as it stands today, the only way that someone would be able to invoke the FMLA to cover a bereavement period after the loss of the individual is to establish that the individual themselves, the employee, has a serious health condition. That often involves mental health conditions, of course, depression, anxiety, but you would need to invoke a serious health condition that's frankly independent of that loss of life. So it does make it difficult for the FMLA to kind of neatly fit a bereavement situation. But it's not uncommon. It's not uncommon where someone has lost a family member or a friend that they ask for additional leave. And in almost all cases, when I'm dealing with this with my client, the client is empathetic to the need for leave. And thankfully, many employers support an extended period of time for that person to take off, but they don't know how to characterize it. It's beyond the 3 days in the company policy. It doesn't really fit the FMLA because the employee may not be communicating what they're dealing with, other than to say, my grandma just died, my husband just died. So that communication is missing in terms of the serious health condition, the mental condition, the medical condition that's required to trigger FMLA.
So how do you tell employers to characterize it? What's sort of your typical advice?
Communication, first of all, is key. Be open with your employer. And again, let's put aside what I would characterize as the far majority of employers who are they're empathetic to the situation. And the response from those employers is generally, take the time you need. We're here to support you. Come back when you're ready to come back. There are plenty of employers, though, that don't have policies on the books. They don't have the ability to provide extended leaves. Here, it's critical to show that your absence is covered by FMLA. So, and where I see the breakdown between employers and employees is, although we as the employer understand that there's been a loss in the family or loss of a friend, we can't divine how that's impacting the employee. And we often don't have enough information. The employee isn't sharing enough with us. The employee doesn't communicate with the employer. They may go AWOL. We may not hear from them. So it's so critical that the employee simply communicate up front. Be candid with your employer. I'm hurting right now. This is a really difficult time for me. I can't keep my attention on my work when I'm dealing with this loss in my life. Explain to your employer what's going on with you. Some of us are fearful of that, right? We're fearful of what the employer may do. We're in fear of losing our job as a result. But it's important to characterize what you're dealing with. If you need to start using the words like, my mental health is at issue here. I need leave for my own mental health. I tell employers that line alone triggers an FMLA obligation. Now we potentially are in an FMLA protected situation. So number one, be candid, have open communication with your employer, but also share as much as you're comfortable, share what you're going through so that the employer has an understanding that, okay, we've now reached the point where our bereavement leave policy may not apply anymore. That's been exhausted, but now we may be entering an FMLA situation that affords this employee job protected leave, at least potentially does.
And I would agree. In our own experience, I think most employers do whatever they can. There's certainly sort of the oddball employers that, intentional, or it's a misalignment of values where it can be more difficult. The other place that at least we've observed a critical communication link is with the supervisor. In some cases that the supervisor provides some advice or allows for leave, but didn't know that the company actually even had a policy to begin with. And so sometimes I think at least from an advocacy or from an employee perspective, we've seen sometimes a miscommunication on that front as well. I just want to, before we move on, and just in case you weren't aware of this, there's just an unfolding dialogue, and I think important dialogue that we have to be, paying attention to from a policy perspective, particularly around normative grief. So, many people are, potentially grieving a loss, and their grief response is completely normal, and it doesn't necessarily require clinical care. And so I'm just sort of sharing this with you in the spirit of, this is a conversation that's unfolding in the grief community right now, because we also don't want, everyone who's grieving a loss to be pathologized. We don't think everyone needs clinical support. We have already a broken healthcare system that doesn't even need to incur more costs. So it's additionally complicated. This conversation is just additionally complicated by that unfolding of the dialogue. I did want to ask you, in our research, we've looked at some DOL, Department of Labor statements and some Senate reports that seem to indicate that at a minimum, miscarriage or stillbirth would be considered a serious health condition. Is that your understanding?
In short, yes. For a couple of reasons, whether it is a miscarriage, stillbirth, what we're dealing with there is an incapacity to work because of pregnancy. So that alone arguably is covered by FMLA. The condition itself may, in addition, may independently be covered by the FMLA. So if you're dealing with either of those kinds of scenarios, we likely have met the definition of a serious health condition. And you're right that in the legislative history, but we're getting into the weeds here, right? The legislative history talks about miscarriage. It makes a specific reference to miscarriage. It doesn't reference things like stillbirth, but I think the same concept applies. We're still talking about an incapacity to work because of pregnancy. And so mom, for instance, needs that time off to recover from childbirth. So whether they need leave from work, whether they need to care for someone who has gone through that, that arguably is covered by FMLA. But again, it should also independently be covered by FMLA because it likely would be considered a serious health condition.
So what you're saying here is that would extend to potentially some paternal or other maternal coverage. So sort of the care provider for the birthing individual would potentially also be able to invoke FMLA to attend to the birthing individual.
Exactly. And that's the strange part about this, right? So dad obviously is impacted by the loss. They can clearly get FMLA to care for their spouse or the mom in this instance. So that's covered by FMLA as she recovers, but their own independent FMLA request is different than mom, right? Because they're of course not recovering from what just occurred. So if it's for their own serious health condition, they have to go through this exercise that I just outlined a few moments ago. So FMLA clearly can apply in these instances. It just doesn't neatly cover these scenarios as frankly it should.
Or in that same vein, do you see time limits, or how is time allocated for, let's say, a miscarriage? Is it access to the full FMLA benefit? Can employers, do they have the opportunity to say, we'll give you 10 days, but we won't give you 12 weeks? Or are there any sort of restraints on or constraints on time allotted?
Yeah, good question. It really is driven by the physician. The physician drives what that recovery period is. Now, if we're talking about a normal childbirth, the typical notion is that for vaginal childbirth, it's a 6-week recovery period. C-section is typically an 8-week recovery period. But we're dealing with something different in miscarriage or stillbirth. That, in some respect, we ultimately want to rely on what the doctor indicates is that recovery period, and that would then cover mom for FMLA leave. And if dad is caring for mom during that time period, it also would arguably cover dad as well. But there isn't, to answer your question directly, there isn't a set time period. That's going to be driven by what the physician indicates.
Can the time ever be taken intermittently, or does it have to be taken consecutively?
The bonding time to bond with a child, with a newborn child or adoption or foster care, strictly bonding time can't be taken intermittently unless the employer allows. But for all other scenarios, in all these scenarios, it would apply miscarriage, stillbirth. Those could lend themselves to intermittent leave. So whether it's due to the recovery, whether it's due to, let's say, a mental health condition that arises out of that loss, those would lend themselves to intermittent FMLA leave. And just to explain to the audience, FMLA comes in different shapes and sizes, right? You could take what's called a continuous leave or a block of FMLA leave. There's also intermittent FMLA leave that we can take typically at different periods of time. And the understanding is that they're likely going that leave will be required for these shorter periods of time over a much longer duration. So those are both different forms of FMLA leave that an employee can take.
Thank you. Can invoking FMLA jeopardize potential bonuses or other incentive opportunities that an employer can offer, that an employer might offer?
It can. If I got into the technicalities, your attendees' eyes would glaze over. But what we're looking at when it comes to a bonus or pay that an employee might be due because they've been on FMLA leave, what we look at is how does the employer treat employees on other forms of non-FMLA leave. So for when you're taking personal leave, when you're taking jury duty leave, other forms of non-FMLA leave, how does the employer treat individuals in those situations? If they pay the bonus to the person who's on non-FMLA leave, they should pay the bonus to the person who has taken FMLA leave. So we're treating the FMLA person the same as someone else who has taken non-FMLA leave.
So I think just going back to your communication point, I think it's really important for the employee or even an ambassador for the employee, sort of given this, depending on the circumstances, to have a conversation with their supervisor or with HR to understand like what are some associated benefits or risks of invoking FMLA. I think sort of open communication to me seems like the best route in that sense. I'm asking, I guess, would you concur?
Oh, sure. Absolutely. I would encourage employees to work directly with human resources. Many employers ask their supervisors not to communicate with employees about medical conditions. And rightfully so. We do want to have as great a confidentiality involved in this process as possible. So while there is some limited information that's shared with supervisors or managers, typically that information about an employee's need for leave, the condition that they're dealing with, and the time period involved, that's all handled typically through human resources or through someone in the leaves department within the company. So it's important to be in full communication with HR or the leave team. And that ultimately can be found in your FMLA policy. So it's important to look at your FMLA policy and see where does your employer want you, who do they want you to communicate with?
On that note, can you talk a little bit about short-term disability and how it relates to FMLA?
Sure. They're often intertwined, but they are two different concepts. So short-term disability is strictly a benefit program. It strictly provides you pay at some percentage of your salary. Usually it's 60 or 66% of your salary while you're on a short-term leave of absence due to your own medical condition. In many cases, short-term disability, or what we call STD benefits, run out usually after either a 12 or a 26-week period of time. And again, that strictly provides you a portion of your pay. That's separate and apart from FMLA. FMLA is, we've defined what FMLA is, but FMLA actually protects your job. It requires your employer to return you to the same or equivalent position when you're ready to return to work at some point in that 12-week period. So that's very different than short-term disability benefits. Many plans, many STD plans allow you to continue your STD benefits even though your employment may have been ended. So two very different concepts. But one last point is the far majority of employers run FMLA leave at the same time as your STD benefits. So you may on day 1 or day 7, depending on what your STD plan says, you will start accruing benefits, but your FMLA leave is going to be exhausted at the same time.
Got it. What about abuse of FMLA or invoking FMLA? Have you, I guess in your experience, is that a common problem? Is that sort of or is that the exception to the rule?
Well, it's the exception to the rule in the sense that the far majority of employees use FMLA for legitimate reasons. But it's the old concept of, we spend 90% of our time on the 10% of troublemakers, right? So it's the 5 to 10% that use leave in very suspicious situations. I had a phone call just the other day with a client who is a transportation client, and their numbers of FMLA use shot through the roof on New Year's Eve and New Year's Day. Well, what a shock, huh? That unfortunately some employees use the holidays, use New Year's Eve and New Year's Day as a way to take off for FMLA. So it's such a small portion of the workforce that your HR folks spend the most time on, and unfortunately, it is a reality. It's sadly human nature at times for some folks to misuse that FMLA process, and it creates the cynicism that affects other people's leaves of absence. That's the unfortunate thing here is those of us on the employer side and in the employer world, we at times grow cynical of certain people's use of FMLA because of the suspicious way that they use that leave. But thankfully, it's a small percentage.
Has COVID impacted employers' willingness to extend bereavement leave or heightened the awareness of it as a benefit? What has your experience been in the last couple of years?
I wouldn't say that it's affected it as to bereavement specifically, but what COVID has done is it has injected into the discussion, both at the federal level and at the state level, the need for work-life balance to come into play as we're considering new laws. It's injected mental health into the conversations that we're having, into these kinds of legislation that Congress and the state legislatures are considering. Some of the concepts that came out, I think we both sides, both the employee and employer side, coming out of COVID, at least half expected some kind of sick leave law to be enacted at the federal level because it was enacted during COVID. And we saw with FFCRA, the law that was passed by Congress at the very beginning of the pandemic to provide leave to employees for COVID-related reasons. We expected that would continue, that paid leave in some respect at a minimum for sick leave would be the law of the land beyond COVID. We certainly expected that as a real possibility, but it hasn't. As we know, that didn't pan out. But like I said, what it's done is it's brought into the conversation the idea that we need to do something different when it comes to childcare issues. our employees who have children at home, and there are going to be issues that arise. We have to care for our child who needs to leave school early, who is sick and at home. That I think there's now a day, sooner rather than later, where we're going to see legislation that protects childcare situations, for instance. That's a positive that's come out of this pandemic, is that there has been a refocus on childcare and family life issues. So will that be a lasting impact in terms of legislation? Yet to be seen, but it certainly has forced, in a good way, those kinds of conversations within our state legislatures and even at the congressional level.
So tell me, how does FMLA federally work with all these state laws? Do they work together? Do they not work together? How do people start to sort of understand those intricacies?
It's a mess, Joelle. It's a mess how they both interact. But they do interact. We have a handful of states that have passed their own FMLA laws, a handful that have passed paid FMLA laws, another handful that have passed paid sick leave laws. And so it's a constant exercise of applying both the federal FMLA to whatever might exist at the state and local level. So it's quite an exercise for employers to balance and calculate all of those different kinds of leave, both at the federal and state level. It requires some coordination between the two. And many of these laws are different. No law is the same as the federal FMLA. So it's covering different kinds of family members. There are different eligibility requirements. There's different entitlements. There's different reasons for leave. So they're all different and they all exhaust at different times. Some of them at the same time, but they always are. There's some portions of every one of those state laws that are exhausting at a different point in time than the federal FMLA.
Do you see in the states, so when I did gubernatorial policy for a long time, we often saw states as the incubators, and we would see sort of innovation coming from the state level. Are there any, one or two trends that you see emerging? You mentioned paid versus unpaid. Are there any trends that you see in those state laws that you think are at least intriguing and may, in fact, serve as a model sort of downstream for other states or the federal government?
Well, it's interesting. We certainly, when it comes to paid FMLA leave, we've seen different concepts that we may end up seeing at the federal level. We've seen insurance type programs where it's an actual insured product. It's not necessarily paid for by any one person. It's part of an insurance fund at the state level. There are other laws that have required both employers and employees to contribute small portions of their paycheck every week to a fund that then provides paid leave when they need it. So I would envision some kind. It's unclear as to whether is it going to be an insurance product, or is it going to be a fund that employers and employees pay themselves. I tend to think the latter. I tend to think that it's going to, if we're going to see something that makes its way out of this morass that we're in right now, whether it's at the state or federal level, I think we're going to likely see a paid leave law, paid FMLA law that involves contributions from either the employer or the employee, or both, a sharing of both, that provides the funding for paid leave. Another model is in the bereavement area, and we're seeing it just this year. We're seeing states like Illinois and California change their own state laws that protect bereavement leave as part of their very own state law. So those are interesting and exciting developments, frankly, that I think will set a course for the future.
And I think that's a great way to sort of wrap this up. I think just understanding predictions for the future and where this might go. Is there anything that you think we've left out that's important for people to know?
Well, it's a bit of an unknown where we're heading. It's in terms of whether it's paid leave or whether it's bereavement type leave. It is heartening to see that some of these states are addressing, for instance, bereavement leave in a way they haven't before, and covering situations, for instance, involving pregnancy. Like Illinois has had a law on the books that covers child bereavement leave. So if for the loss of a child, for the law has covered that instance for a number of years. As of January 1st this year, it now covers bereavement leave for up to 10 days for the loss of a family member. So that's quite a development. And the entitlement itself, 10 days. California's law that just became effective in this January as well provides for 5 days. So we're starting to see some developments in that area. But in terms of advice to the typical person that needs help because they've lost someone very special to them, I would strongly encourage you to communicate fully with your employer. It may be really difficult to do so. It may be difficult to share those raw feelings, the raw emotion. But I think what you're going to find far more often than not is an empathetic employer on the other side that simply wants to help you, simply wants to have an understanding of what you're dealing with and why you need leave from work, and is ready to support you. And if they're not, at least you've communicated with them enough facts that likely launches this into an FMLA conversation. And if they're not willing to voluntarily help you, you have now the federal FMLA that stands behind you to protect leave in instances where you are dealing with the loss of life that impacts you in a way that potentially is covered by the FMLA.
And I appreciate that. I want to make sure that folks know where to find you. And I think your blog, as I said earlier, is absolutely stupendous. And one of the things that you do annually is your FMLA song. So I'm wondering if there was a 2022 song. You did not. We didn't list that at the top as far as your background and credentials. That you are also a songwriter and singer, at least when it comes.
Part of my credentials is that I'm a terrible singer. That's what my credentials are. I'm a horrible singer. Yes, this is, I guess become one of my trademarks is, yes, I hold an annual webinar where, yes, I sing. Usually it's a holiday jingle that I sing to FMLA or ADA lyrics, and they usually are poking fun at employers. I'm an equal opportunity I guess harasser, in that I poke fun at employers, employees, doctors, whatever, everyone involved in the FMLA process. I have a little fun with them. But thankfully for your audience, I think we're at the end of our time, right? So there's no singing today.
No singing today. All right. Well, we'll let you off the hook for today, but we do have one more question that we asked our panelists that come in. And that is, if you're stuck on a stranded island with a group of other colleagues, what are you listening to? And then what function are you serving that community? What will you naturally sort of matriculate towards if you were stuck on a stranded island?
Holy cow. So what am I listening to? Meaning like music? Like, oh, interesting.
Yeah.
I am, well, if I'm personally listening to something like my own interests, I'm probably listening to someone like Elton John or Billy Joel. If I'm listening to What I'm hooked on right now because of my high school senior, I'm listening to AJR. Can't believe I would ever admit that. He's gonna play this on YouTube forever now. But that's what I'm listening to. If I'm stranded on the island, I'm probably going to take way too much of a leadership role. And I'm like in Survivor, I'm probably going to get voted off the island way too soon because
Very honest.
I'm probably going to get in someone's face and then I'm going to screw things up and I'm going to get voted out.
Yeah, you're an advocate. That's what we do. That's
Yeah.
at heart. That's
Well,
what we
yeah.
do, is sort of fight for people. Well, it's wonderful to have you on today. Before folks sign off, we'll just let you know that we have our next In the Know, February 15th at 2 p.m. with Dr. Mary Frances O'Connor, who is not just a brilliant author of The Grieving Brain, but she is a brilliant basic scientist and is really pioneering how grief and bereavement show up neurologically and immunologically. And so what are those physiological impacts that grief and bereavement have on individuals? So we hope that you'll join us then. And thank you so much. Thanks, Jeff, for being here.
Great to be with you, Joelle.
All right, take care. Bye-bye.
Bye.